The topic that's going to be presented is one of a dichotomy. While cultural, religious, and racial aspects in a custody matter requires the court to enter into an unusual role, while there's clear separation of church and state in the United States, in which a judge should not be involved in any religious matters, custody is different. For in these matters, as the presentation will exhibit, it is imperative that the people involved, including the judge, become knowledgeable in the various intricacies of religion, culture, and racial aspects, so that they can make a best interest determination on custody. Additionally, while the cases that will be examined will clearly exhibit that the court has and does imply and determine religious restrictions and religious compliance in the raising of children that have been raised under those tenets of religion and culture throughout their lives. Thus, unlike other cases, the court will become knowledgeable and informed, and it is the attorney's job to ensure such, and to the effect that if there is a bias in the procedure through the attorney for the child, the forensic evaluator, or the judge, that be brought to the limelight and dealt with in the context of these cases. We are here on racial, cultural, and religious factors in child custody evaluations, attorney advocacy, and judicial decisions. My name is Martin Friedlander. I'm a matrimonial attorney, and I'm with.
Hi, my name is Dr. Leigh Younger. I'm a psychologist in private practice.
Okay. We're going to start to describe issues that are applicable in custody matters where there is a discrepancy or disagreement between parents, whether it's in regard to race, religion, or culture. And that has many factors as part of it, in the fact that there may be two parents that when they were married, they were on the similar page in any of these issues. And then one during the course of their marriage or during the part of the case where the divorce commences, and they decide that they want to change lifestyle patterns for a host of reasons. And obviously there's the reverse, where the parents were on the same page during the marriage, during the time that they raised the children, and then one parent decides that they want to change their lifestyle, either adhering to religion or adapting race and cultural sensitivities that they did not care for earlier in the case in which they were raising the children.
Before we jump into any of the specific cases, this might be a little bit dry, but I think it's important that we just take a minute to define the variables that were just named. So today when we talk about race, we're referring to a group of individuals sharing outward physical characteristics and some commonalities of shared ancestry. When we talk about culture, we're referring to the customs, arts, social institutions, achievements, beliefs, behaviors, values, and morals of a particular nation, people, or other social group. Culture is learned and shared amongst the people within a given culture. Then there's this idea of cultural relativism, which is the principle that understanding the beliefs and actions of individuals must be predicated on understanding the cultures in which they were raised and within which they currently live. When we talk about religion, we're referring to a particular system of faith and worship, such as attitudes and practices. Now, I also want to point out that value systems and behavioral practices vary across and within race, culture, and religion. And it's important to kind of keep that in mind because there's going to be individual differences even within a particular group. So attitudes regarding firearms, gender roles, time spent on educational activities versus extracurricular activities, ideas about alcohol and marijuana consumption, technology use, diet, the way we understand and process nonverbal language, body gestures, parent rights versus child rights. All of these ideas, I think we try to think about in this group they do it like this, and in that group they do it like that. But it's important to not overgeneralize, because you always have to remember the individual with whom you're evaluating, treating, or litigating on behalf of, because there will be individual differences.